Hey, everybody. We're live. We have JB. Good to see you, JB. Greg Sisk and Aaron Hall. John Cook, good to be with you. So I need to start right off. Aaron, last night I was already asleep, apparently, because I didn't see it till this morning. But as expected, once Judge made a canceled oral argument on Sunday evening, he tossed the Bou Jabbour motion. So tell us about that.
Yeah, so we had filed a motion for a preliminary injunction on behalf of our 12 remaining clients. It was 13 at the time we filed it, but then somebody got scheduled. And so it was 12 remaining unscheduled plaintiffs. And we had asked that they either be ordered to do everything possible to adjudicate their applications before October 1st, or in the alternative that they reserve, that the court order the Department of State to reserve visas for those people. And the back and forth in the briefing was about whether they had actually followed any kind of order or the order that they had said they were following. And we went back and forth and were set for argument yesterday. And then the night before, as Chuck said, they canceled it. And I think we kind of saw the writing on the wall at that point. And so Judge Mehta denied the request in an order last night. And I mean, what it boils down to is he is saying that nobody is guaranteed a diversity visa interview, and that the court is not going to, or is not interested in kind of micromanaging who of the selectees gets a visa. If the department seems to be administering the program in good faith, and I think the undertone to all of this is that the fact that they're going to get near the 55,000 this year means it's in good faith, then that's good enough for the courts. And that seems to be what's happening in other DV cases as well.
Yeah, so bottom line is, and it was at 9:30 last night when he issued his decision, you can't fault the judge. I mean, the reality is, when we filed this case, they had adjudicated less than 5,000 DVs in the first half of the year. So, I mean, maybe it's 6. It was something like that, right? It was a tiny number. So they were clearly not doing their job. So first of all, we forced the government to do their job. And you know what? They did it. It's the exact same thing that CIS did in the Madhavan case, in the DEB Wastage case. They did the job. Now, they did a terrible job doing their job. The judge didn't, and kind of addressed this a little bit, Aaron, but didn't really address it in that, yeah, they took cases out of order. He kind of ignored that part of our motion, which I thought was very compelling and backed up by a massive number of facts. But it'd say, well, people got, some people got it, some people didn't. And obviously, the other issue on all this was the Department of State changed how they process these cases in the middle of the fiscal year. So some people that waited to process and send their documents in got approved, and some that were, documentarily qualified weren't approved before they changed the process. Clearly, it's the same nightmare that occurred in the EB I-140 situation for EB2s and EB3s. But the reality is the court is not going to step into that. They do not want to get involved in the minutia. So, Aaron, I know somebody's already asked, do we appeal this? And I want to say no.
Yeah, I've taken some emails on that too. First, I'll start by saying when we actually filed this case in February, I don't have the exact date in front of me, the latest published statistics from the Department of State said that through the first quarter of the fiscal year, they had issued 208 diversity visas.
I knew it wasn't a lot. So
that's what we were looking at when we brought this case. And the facts on the ground, I think because of not only our litigation, but other litigation, and also because of some pressure on the department, probably from the DV community and also from members of Congress a little bit, got them to get in gear, and they were frantically scheduling and issuing the visas, and I think that them putting themselves behind the 8 ball in the first half of the year led to the kind of chaotic nature of how how it played out to get up to the numbers that they wanted to get to. So I mean, I'm happy that that they're going to get to near 55,000. That's fantastic. But
I mean, that may be more than we've seen in a decade.
But it's disappointing.
Jesse, Jesse's issue is a little bit different.
I mean, it's the problem. I mean, it's like a 90% win, but for the 10% that didn't win, it's a total loss. So we get it, and and there's nothing we're going to be able to say that's going to make those people feel better about it. So, but that's where we are.
Yeah, let me get back to that question about an appeal. So, the case that we generally rely on for the authority to reserve visas beyond the fiscal year seems to indicate that they can be reserved where some relief is ordered before the close of the fiscal year.
Well, that's our position, right? I mean,
but that's not what's going to happen here. So if we appeal it, we're in a worse position than we are, for example, in the case that's up at the Court of Appeals for DV 2020 and 21. So that's one very good reason not to appeal, or that we don't think it's a very viable case. And the other is it's a different factual scenario than the past years were. And we're not seeing district court judges really want to get involved in who amongst the selectees are able to get their visas, as long as they're administering it in good faith. And I'm not sure that there's a good likelihood that the appeals court is going to be any more interested in getting involved in the weeds there.
Not based on the oral argument Jesse and I attended last week. Jesse had a similar outcome, but yours is in some ways worse because some consulates basically abandoned doing Ds for you.
Yeah. And Meta had a case. I had an individual case that was related to your case that Meta issued a short order yesterday, and it was from a single DV female applicant from Accra, and we put the facts before the judge that that was one consulate that really totally turned away from the program this year, and he kind of acknowledged it, but he also said at the same time that this is not 2020 and 2021 where they had a policy to blanketly withhold adjudication. And I think that's where these cases are ultimately going to come down.
But Jesse, they did in Accra.
Yeah, I think at a micro level, they certainly did. And I think he acknowledged it. I think what the judges want, pretty much, they've been emphatic about it, that if it's not at 30,000 feet, at the State Department level, they're not going to be involved in DV. And I think for those in the audience who are 2023 winners or 24, like don't look to litigation unless we have that blanket policy. And that's new. That's something we didn't know. And in fact, they did have a blanket policy when these lawsuits were filed. Yeah. At least the ones that we filed. But I mean, I think the parallel between the Madhavan case and the DV litigation all revolves around, there's a central player in this, and that is the visa bulletin. And when they made all DV current, probably too early, and they put numbers where they did for the EB, what they did was they allowed the issuance of visas in the out of order consideration for both programs, right? Yeah. And that seemed great at first, right? Everyone was excited. I'm current. And of course, there were multiple thousands of people who benefited, but those that didn't, especially in the EB context now, are left kind of holding the bag because they played the game where they pulled the string on us on retrogression. And I, again, that they definitely manipulated the visa bulletin both ways. But that's something that I really do think that interfered with both programs.
I know the visa bulletin DV, they did that actually all 3 years. They made the bulletin available early all 3 years. So it's clearly historical context to doing this.
All Jesse, right, so did you have any other thoughts about people's questions about appeals?
Well, just let's think about it practically. I mean, how are you going to get relief in the next 2 days? Because the cases in every court forever say that you need relief before 9:30 or on 9:30, and you're just not going to get that, unfortunately. And
Meda is well aware. I mean, this is probably the most informed judge in the country when it comes to how the DV program works. So
Yep.
we're not gonna change his mind.
All right. So so we're going to switch over real quick here to the EB wastage mandamus litigation about where we are and where we're going. Who wants to take a lead on that one? I will just briefly say that I have had discussions with government counsel, and USCIS will not agree to adjudicate our remaining plaintiffs who are current on 10-1. On 10-1, they will not agree to do that. And they basically have refused to answer the question on spouses. They basically have not given us any answer on those spouses, in which they clearly violated federal law. Clearly violated federal law. Their excuse is, well, sometimes spouses get separated. And it was like, okay, I get that. But this is like 12 of our people. So this, statistically speaking, this is a lot. This is like in 5 cases. That's insane.
My question for you and Aaron on that is, how many times in your career has that happened?
Maybe 3 in 30 years. Maybe 3 times.
Yeah, super rare.
This is statistically significant deviation from the norm. I think we have a pretty representative sample.
Yeah.
So it's insane. So,
I've had one case in 32 years of doing this where a spouse where there was a retrogression of a spouse, and it was in a consular case where a nurse was in the United States and waiting for a spouse to come and join her, and the numbers retrogressed. It was about 15 years ago. That is the only time that has ever happened to us.
I was simply referring to the spouse not getting approved with the spouse.
Right.
That hardly ever happens, let alone a retrogression. A retrogression they knew was coming.
Right. And they could have held numbers for those spouses if for some reason they were adjudicating them in different locations.
Absolutely. And that happened in at least one case of ours, I think. Happened in at least one case where the officer called for 2 numbers and got 2 numbers. And I don't know if you noticed this one little blurb that was tweeted by the government after our discussion with the U.S. attorney. My U.S. attorney was, for those people that got approved after we ran out of visas, we can't tell you what happened, but maybe the officer got a number, and we don't know. Blah blah blah.
They certainly. I have a list of almost 1,000 people right now who were approved in September, and my best analysis of what I see is that there are specific officers and offices that called ahead of time, maybe when the interview notice went out, or maybe when they got the medical RFE back. They did it. There's no explanation. And of course, you could get the approval and it could say on the 797, which is that receipt, it could say September 22nd. But in fact, that visa was pulled a long time ago, which is not going to satisfy anyone in the audience. But it's the best explanation I have as to what happened. Are we going to probably see a couple more approvals? Probably. But I don't think that visas are actually being issued. I think that they've been pulled. And it's not fair. Everyone's like, hey, it's not a fair process. And I'm like, yeah, well, no,
by the way, the last thing, Jesse, is they still have not explained what they mean by the word allocated. What does that mean? We allocated visas to these people, but they didn't get them. Yeah, then you didn't allocate visas to them. That's not how that word is used.
They can't tell the truth. If we're expecting the government to come tell us the truth at this point, we're fools.
It's insane.
I don't even think a lot of them even know what the truth is. Seems like you get different answers from different people.
Right. Let me go back to the DV, because I actually had a deposition with Morgan Miles for the KCC director. Okay. It is very obvious, as nice as he may be, that he has absolutely no idea how the software runs, where they pull numbers and get people into lines. And I feel like that's the same thing that's probably happening with states visa office and the numbers for USCIS adjustments. The systems don't talk, and if they do, they're inconsistent or arbitrary. And that's why you have PDs, priority dates that were in applications that were adjudicated in May, June, July 2022 filers for 2014 priority dates and 2013 priority dates. And like, you would have thought, if we have 280,000 visas to issue in fiscal year 2022 and we opened it up for a lot of people in 2020, we would get through that. Those cases, because they would actually go in order like the law says, and they just didn't. And we have a ton of them.
So
I think there's 80,000.
So Jesse, Greg, what are we doing about that?
All right. Well, first of all, Madhavan, that case still lives because we have a number of plaintiffs that have still have current priority dates on October 1st. So in about 3 days, their relief is available to them again for that group of plaintiffs. It's not a big group, but which is, says a lot about the fact that about 60% of our plaintiffs already got their green cards that are in that case. But that the case remains live for them. We are making a determination on how going forward for the remainder of the plaintiffs there. But we are for sure working on a new case, which we started onboarding over the weekend. And that case is going to be, Jesse, I think we're filing it in DC, or that's the likely location we're filing it, where we're suing both the State Department and USCIS. And the State Department, the major issue is what we've been talking about here, which is that there was a violation of INA 203E, which talks about the order of issuance of green cards, which the State Department did not abide by by that section of the law, and we will be suing on behalf of people who had long-standing adjustment applications that were skipped over. Basically, people who were ready to go, had current priority dates as of September 7th, filed their cases before January 1st, 2022, because we're only focusing in this case on people who had long-standing adjustment applications. And we are going to see if we can get relief there, which, Jesse, maybe you can talk a little bit about this, but basically it's definitely the message we want to make sure people understand is that this is not a slam dunk case. What we're asking to have done is provide equitable relief involving the visa bulletin. But Jesse, why don't you talk about that?
Yeah, no, I mean, this is like me going and try and dunk again like I did in high school. Right? That's where this is, because it's no. And the reason we're filing in DC is because there are cases that are supportive of this view of the law, that it's plain for split spouses, that they actually have to be in the same status and adjudicated that way, and that there's a specific statutory provision that says visa numbers have to be issued by priority date. And in fact, that's what the government said in the Madhavan case, right? But they didn't do it. The difficulty in our case, and it really is on the relief side. So we can win on the law, and I'm confident that we would, and that we will. But a judge is going to have to really look at his equitable or her equitable authority to say, okay, what can I do about this? Because a lot of cases out there say, I can't really do a lot if you're not current and a visa is not immediately available. Now, what can litigation do outside of the specific contours of a case? Well, maybe USCIS and DOS will get together and recognize the error and move the dates back to where they probably should be. And that's a huge win. And because if people become current again and they start adjudicating in order as they should, that's a win. And it's not, it wouldn't require a judicial order. But absolutely 100%, anyone who is going to join the fight needs to understand the risks, needs to understand that what we're doing here is taking solid basis legal arguments and asking a judge for an equitable remedy, one that's, definitely equity is right, is about fairness, definitely fair. But on the other hand, not something that's been done before. So it's much different from saying that retrogression is unlawful. I know there's legal claims out there on that. We're not doing that. I think what we have is the best argument to make, to try to expose concrete errors of law. Like, we have definite evidence that people were getting adjudicated with 2014 priority dates, and that filed in June, and the law would say you can't do that. So that's where we're targeting. And what we're trying to really do is make sure those that have been quote unquote skipped have an avenue for relief, rather than hopefully, and not hopefully having to wait years to get their benefits of an EAD, maybe, and advanced parole, maybe.
Right. We're also going to be making an argument regarding how the numbers actually roll over and how they're allocated to backlog folks as well, because we think that the overall numbers that should be going to India and China and
they're manipulating those numbers too, and they're violating the law there as well. I would note that the government has told us that they're going to file a motion to dismiss. We're going to dismiss every plaintiff that was approved, along with a couple other people who decided to file a different lawsuit. They're out as well. The government also indicated they may file what's called a motion to sever to separate the remaining cases. Obviously, we're not going to get into a Chakrabarty situation again. If those current plaintiffs that want to do continue forward in the new case, if they want to. But that's kind of where we are. We should be hearing from the government today, and we'll send that out to our plaintiffs as well. I do want to just also mention that the Kang EAD litigation, Judge Leon issued a honestly terrible decision in that case on our class status, because all of our plaintiffs were approved long ago. Says, well, yeah, they're busy. That's basically the good Judge Leon said. Aaron, what do you want to add to that, other than we're going to sue them again?
Yeah, I mean, there was one big fact that changed after we filed the lawsuit, and that was that USCIS, under lots of pressure, decided to extend the auto extension to 540 days rather than 180 days. That helps a very specific subset of people, right, who are doing renewals on auto extension eligible categories. But if you file an initial EAD application, you're still looking at how many months? I don't know, 10, 12?
9 right now.
14? Who knows?
9 a minimum.
So the judge saw that change and said, well, for renewals, they haven't proved, or they haven't established that anybody's going to suffer harm, because you have this new 540-day extension. And he really leaned on that in dismissing the case. And then he said, because the actual named plaintiffs had been approved, that there was no controversy basically for the court to decide.
But he blew off the case law on that issue. I mean,
yeah, to us, it's a little bit silly. I mean, the facts have changed a little bit, but it's a little bit silly to just be doing that and having the same claims be refiled as soon as, basically as soon as people are ready to sue. It's just not going to solve the problem, and the courts are just going to see these cases all around the country until either a class action is certified and we get a decision, or the agency fixes its problems.
Well, we're prepared to move forward again, aren't we, on this? We're going to announce.
We will. We in the next probably the next 48 hours, we will start onboarding for a new EAD litigation case, and it's going to look very similar to Kang, which was great for our plaintiffs in that case, where they all got approved in relatively quickly. I think it was all within 90 days or so for almost all of them within the suit being filed. And if you go back and watch the recordings of this live stream when that happened, and when the government was fighting us on the class certification, we were saying that it's like, if you're not going to fix the policy, and you're going to oppose us on a class, we're just going to come back and do it again, because that's the only way that these people can get relief.
Yeah. Well, they fixed the policy on DVs. They've somehow fixed the I-140 policy, supposedly. Maybe another lawsuit's all they need. So we're going to move on that.
Well, the one point though is what's slightly different is because their fix for the EAD times was to split it from advanced parole, right? So we should talk about that. Like that is ridiculous. And actually people sometimes want advanced parole if they have other status to work. So that is going to be a big deal. Like I think that is a giant issue that we need, I know we're doing it, but
we're going to include advanced parole delays in this. And
so we're definitely suing on advanced paroles. We are at this point still strategizing about whether it's going to be joint or separate, those cases.
So we'll
probably separate.
United for Ukraine, Jesse, the government has made a poor decision in this case, a very poor decision. So what are we doing?
Well, I don't know if they've made the poor decision yet. They certainly are preparing to make a poor decision and not settling. And again, I don't know. I always have this thing, just so the audience knows, again, in the back of my mind, when it keeps me up at night is I'm always like, well, if I'm overconfident, then I'm wrong. Again, but everyone I talk to reads the law the same way we do, which is that anyone who was admitted under the Ukrainian Appropriations Act, I'm not saying that correctly, but something like that, was entitled to work incidents of status, and they shouldn't have to pay $410 for an EAD card. And, we have a preliminary injunction on file, and the government was granted until October 5th to respond. I was frustrated, I guess, yesterday when I got the emails and I started to just hammer away at a motion for class certification.
Good.
That's how I responded. I know Chuck, you took a quick look. I know Aaron made to take a look. So that's where we're going. I mean, I think these people are suffering. I mean, we just talked about EAD delays. So, right. So if you have to get in the queue, when you don't even have to, everybody is suffering.
Everybody suffers. Right.
But
it's an extra 100,000 applications you didn't need.
This is why you shouldn't lose sleep on whether you're reading it too broadly or not, the statute. And that is, if the government has a legal theory that they can use to give these people automatic work authorization, even if it was gray, which I don't think it is, I think this is totally black and white. But even if there was sort of it was debatable, why would the government not take the road of giving these people quick work authorization? It's good for them. It takes the workload off of them of 100,000 cases that they don't have to work on. And it's good for the U.S. economy, where we get all these workers into the workforce faster. And it's obviously good for the Ukrainians who need money, have families that they're supporting back home, they have expenses. There is no, unless we were so off that there was no conceivable legal way that our argument would work, they should have settled with us.
Well, this is why I like connecting the dots, right, between DV, EB, EAD delays, and Ukraine. If they're not going to help these people, forget it, right? Like we're in a tough spot.
You had a great tweet on that, Jesse, last night. It was really good.
But I do think, though, I'll give the government, I use the word hope. Everyone asks me, is there any hope, right? All the time. Like, that's the only question I get, and it's the only one I can't answer. But on this one, the government attorney did come back to me because I was like, come on. And she said that they're still considering whether they'll agree to a resolution. So,
okay. Well, Greg, I actually have 40 million reasons why the government did this.
41. But yeah,
1 million. Hey, just a quick update on the Jane case. We're getting discovery from the government on October 20th or 21st. Then we're going to see if we get to do depositions at that point, or we need to. So our friend Matt Galati also had a really good victory in Missouri on an EB-5 case. Shout out to Matt Galati on that. Good job, Matt. One of the first ones like that in the United States. He ended up getting a pretty good judge. All right, let's answer a couple questions here. See what we got. We've got first up here, Evans. Hi, good people. Well, hello. Estelle Woodgate, thank you for what you do for us. Happy to be one of those with visas. Oh, you're welcome, Estelle. Congratulations to you. Welcome to America. Get
Estelle's
here
good.
within the 6 months.
I think Estelle is an Aussie.
Yeah, it's got to be. That's clearly she's not from
or
Ghana.
South Africa.
Yeah.
I don't know. She's one of the two, but yeah.
But
she's great.
Estelle, please don't wait. Remember all the people. How many? There must have been several hundred people who got DVs in early 2020 that never got here, because they didn't get on an airplane. Get on an airplane. And congrats. Frostman, Guards DV 21 stay, red judgment stay, in which the end notice stay is valid until the Court of Appeals is good to explain it. It just means judge reserved the numbers until the Court of Appeals makes a decision. That's all.
Yeah.
I was really looking forward to getting in front of the judge on Monday, by the way, and said, Judge, I hope I don't have to see you again next year. Jesse, we should have gone up and said hello to him. We should have gone upstairs.
Chimetta? No.
When we were in court, well, we're in the same building.
Right? He probably had January 6 cases he's working on it day in, day out.
It certainly does.
Go! Yeah, go. It's still pending. Super Bimus, in case we would appeal, how few Go players are not going to be guaranteed interview. I don't know how many Go plaintiffs there are, but keep in mind, if the court doesn't raise the number, it's a food fight, So I don't know. We just don't know the answer to that question. Sandeep, we are not going to answer your question.
Yeah, not appropriate.
If appeal goes in, if it can Go plaintiff B1, B2, so do A1S, ENS, and that's an interesting question. And honestly, I don't see why not. But I don't have an answer to your question. Can you please update CP Mandamus Latanga? Oh, this is the EB5 case for I don't forget where it's pending, California. I don't have an update because I'm not personally handling that. Is that Zach doing that one, Aaron?
Yeah, Zach has been working on that. The motion to the opposition to the motion to dismiss was filed, I want to say, on Tuesday, a week ago. So that's that puts the ball back in the government's court for
this week, right? They probably respond this week, and then the court gets the case. So it's kind of the update. Can we discuss about strategy in private calls instead of public? Since US, Vasu, we know exactly who we're talking to when we're on YouTube.
I don't think. I disagree with that. I don't understand why a lack of transparency when we're asking for transparency from the government is a bad thing. You can have my argument. The cases are all there published.
Yeah, we're not afraid of our argument. We're
get Alexis. Yeah, get Alexis subscription. It's fine. It's just like
So it's pretty sure he says yes. It's the same. I'm not worried about it. How is it different from Madhavan, even in case he said it was not FIFO, retrograde Shapa? So what different? I think Greg went into that. Take a look at the.
Well, first of all, we're suing the State Department on this new case, and we didn't sue them on the.
We're suing state, which is a big deal.
I think it is critical to understand that what the government used to say about its first in, first out was not so much on priority dates, but it was all when you filed the 485, and now they're coming and changing that methodology and saying we do it by priority date. And sort of saying that, but they're not really committing to an identifiable rationale. But certainly those two component agencies work together, and the rule is in the statute as far as the visa issuance is concerned. And so it is much different than Madhavan. The arguments They changed the game. We have to change.
They changed the game, so we changed the lawsuit. So that's why it's different.
Yeah.
Any consideration for women in Iran? Not from Go, there won't be, but it's awful what's happening over there.
Yeah, I saw on Twitter that I think Curtis had a case for Iranian DV winners that he didn't get a good result. Just like none of us got good results at the end of the day out there. And unfortunately, I feel really bad about that. But the as far as the DV cases go, but I don't see at this point that we're going to be able to get any relief.
Hey Jesse, Bemis wants your email address.
I have 7 now because I've had so many jobs in 2020. You can pick one of them. I don't. Yeah, you can if you can't find it. It's Jesse. Try this one. Jesse at wbf-law.com. Go ahead.
There you go. Do we have a Zoom call with Madhavan? We will schedule a call once we get the government's response. and have a strategy and get back with everybody. But we will not be a call this Wednesday yet. We're waiting to see what happens today. We'll email everybody as we always do. Frostman, do I know? I mean, decision until the opinion gets released and the stay is over. So the stay is, I mean, if we win the appeal, the stay it's not necessary anymore because we won the appeal. And then it's a question. He remands it back to Meta, and then we figure out how they're going to do this. So, it'll end up back in Judge Meta's. I'm sure he's excited to see that. So there we go. That's today's questions. Not a lot of questions today. Good to see everybody. Thanks for participating. We'll see you next Tuesday. I'll be live tomorrow at 1. Aaron, are you live on Thursday? Thursday. Greg, you gonna live?
Hiatus.
Hiatus. And Jesse, you doing any lives?
I'll wait. All the people who email me will get on a group Zoom.
There
together.
you go.
That's my
All right.
that's my vibe.
We'll see everybody next week. Bye-bye.
All right.